Welcome to episode number 13 of Upstate and Litigate. I'm John DeGasperis, a partner at the law firm of Basch Keegan.
I'm Derek Spada. On today's podcast, we're going to talk about wrongful death claims and cases. But before we jump into it, let's talk about a few recent victories. John, what do you have?
Well, yesterday we got a great judicial opinion from a trial judge. I tried a product liability case in front of this judge. That was my first product liability trial. I think it was a difficult trial. We had a machine that was 30 plus years old that had never hurt anyone on any prior occasion. But on the date of my client's accident, it hurt him, and it hurt him quite badly. You were involved in that case because after I won the trial, it was a liability-only trial because of COVID. So we went to the jury to try the issue of liability only. The jury did not learn about the plaintiff's injuries. We won the trial, and then the defense, the product manufacturer, challenged the jury's award or determination, their verdict. That's the right way to say it. And then we brought you out of the bullpen to help with the post-trial briefing of their application. And we got the decision yesterday. The judge ruled in our favor. She upheld the integrity of the jury's verdict. I think it was a good decision, a sound decision. This results in justice and fairness for our injured client. Now we have to have a trial on the issue of liability or damages only. So now we will put in front of a jury the proof surrounding the injuries. And I think we agree it's an extraordinary case. The gentleman suffered really horrible injuries. He never went back to work. So he's got both a very serious injury that resulted in some profound surgical intervention, plus very substantial economic harm. So I'm excited about both the decision and where we're going to go from here.
And on that case, it was one where the defense, I would say, tried everything to defend the case. They made every argument imaginable. I mean, some had maybe some merit to them, theoretically, but some had no merit. But they made every argument they could possibly think of. And even with the trial, I remember it was back in 2022 was the liability trial. But the other attorney just did everything possible to defend the case. It was there was no limit on the amount of expense or time or anything that the manufacturer or their insurance company put on this case.
They spent over $100,000 on their liability expert. That doesn't even include their medical expert, just $100,000 on their liability expert. They flew him all across the country to look at other similar machines. And I remember the first time I learned that was in the midst of the trial. And I coughed. I laughed out loud because I thought, wow, that's extraordinary. And then in my recent trial, I spent $85,000 on my expert, so I get it.
It happens sometimes.
Yeah. That was a good one. That was a good team result. That was, we worked together and got a good result for the client. So I think that's one of the advantages of Basch and Keegan. All right. So Derek, how about you? Any recent wins you want to talk about?
What do I have? Well, I had a trial the first week of the year, and the church case. So my client was a local church. And their rectory was a house, as most rectories are. And the property across the street was an apartment complex. And the water main going into the apartment complex broke, and it leaked for about 4 days before it was apparently discovered and shut off. And so for the first 3 days, there was nothing at all in the rectory across the street. The basement was dry. But then on the fourth day, I guess the water just kept expanding as it was flowing underground. On the fourth day, it was like the basement flooded, and just flood, but it was a pressurized flood, and it came in from all sides of the house. And so the foundation walls, all 4 foundation walls cracked and bowed inward. They all shifted inward from the massive amount of water that flowed in. And the pipe that broke was a substantial pipe because it fed water to, I believe, about 59 apartments. So it was a lot of water that was able to go through that pipe. And so that was the case. And then the issue was whether the apartment complex was liable or not. That was the main issue in the case. What courts have held over the years is that an underground water pipe doesn't ordinarily break in the absence of negligence. So either it was improperly installed, somebody like drove over it, because it was under the lawn, or something happened that the apartment complex knew or should have known about that resulted in this break. When that occurred, the apartment complex claimed that they knew nothing about this for 4 days, but I find it hard to believe that 59 apartments with over 100 residents in total did not complain at all about any kind of decrease in water pressure. So that I think was like the best argument that I had, is that this went on for 4 days, which the city of Kingston was aware of this going on for 4 days, but couldn't find the leak. And then on the fourth day, the city eventually helped the apartment complex find it once the place flooded across the street. But nonetheless, the verdict was in my client's favor, and we got basically every cent that we asked for.
That's good. Yeah, that was a good result.
Yep.
And that was a bench trial. That was not a jury trial.
Yeah, bench trial with the judge.
Yep. So. And she did something that is a new trend, but somewhat unusual. She made a decision from the bench using a verdict sheet that traditionally would be provided to the jury, right?
Yes, yeah.
Yeah. So now, typically, if you have a bench trial, you have to brief the case for the judge after the trial and wait an eternity until you get a decision. But the new trend is that the judges will just fill out a verdict sheet right then and there and give you the decision and the award. Did you have to waive the appeal or something of that nature?
No. We just both agreed to do a verdict. So
Okay.
I guess we both have a right to an appeal.
Okay.
Theoretically.
Yeah. No, it's a good result.
Yeah.
All right. Well, today's case in chief is about wrongful death here in New York, wrongful death claims, and we're going to discuss the nature of a wrongful death claim, the damages that families are entitled to, the statutory makeup of our law here in New York, and maybe we'll talk a little bit about some recent legislative attempts here in New York in an effort to change the law. But why don't you first provide the listeners with a basic understanding of New York State's current wrongful death statute?
Well, to break it down into simplistic terms, the wrongful death statute in New York State is, I think it's 176 years old. That's when it was written. And it's really premised on economic loss. And I guess times were different 176 years ago than they are now. So if someone dies as a result of someone else's negligence, there's different components, I'll say, of that death. So one is, of course, the grieving of the family members, whether it's a child who lost their parents or vice versa, or husband who lost a wife, however the breakdown is. But so there's that. There's the emotional issue of the survivors, but then there's an economic issue. So if someone was employed and at a good job, making good money, they would have an economic loss that can be calculated. So if they're making $80,000 a year and they're say 40 years old, then you could say that they would have expected to work until age 65, so maybe 25 more years, and you could figure out the math on their expected lost earnings, factor in inflation and whatnot. But if the person is, I'll say, unemployed, or if the person is a child and doesn't work, then there's no economic component to that death. And that's the hang-up, if you will, with the wrongful death statute in New York State, is that it's really purely economic at this point.
Right. Yeah, they call it the pecuniary loss, right? The monetary loss that the distributees, meaning usually the direct family members, suffer as a result of the untimely death of a family member. Now, it doesn't always have to be family. Your distributee can just be the person who would inherit under laws of intestacy, and so one of the obvious reasons why this statute is really unfair and outdated is, for example, an infant child. If an infant child dies because of someone else's negligence, that child has little to no economic value to his or her parents, right? And quite the contrary, he's an economic drain, he or she, the child, because mom and dad have to pay to feed the child and house the child and keep him or her healthy. So There's no economic value to that child's life. And so if a tractor trailer driver falls asleep behind the wheel or is driving while high on methamphetamines and kills that child, the parents have no real claim for economic harm. And I think to most people that's shocking and would seem unjust. Now go to the other extreme, an elderly person who is abused in a nursing facility, 90-year-old person, has little to no economic value to his or her family, but it doesn't mean that they don't have value as a human life, right? Or value on a moral or emotional level to the family. But that if that 90-year-old senior or elderly person dies while in the care of a nursing facility, the family has no meaningful recovery under the law's current format.
Yeah. And based on the current law, theoretically at least, if a person is injured, I'll say, less than moderately injured, has, some injuries, but not life-altering injuries, that person's case is worth more than a wrongful death case of someone who's either a child or unemployed, which makes no sense. But that's the law in New York State.
I will say this. In the law, we're always measuring culpability based on reasonableness, right? We're not going to hold somebody responsible unless the injury or the damage was reasonably foreseeable. So I can understand to some extent that the current law, which I don't agree with, has some restraint or constraint there in terms of how damages will be measured based on what's reasonably foreseeable, right? And so I think that the idea is that emotional damages of family members could be wildly out of proportion to the act of negligence. So if you happen to kill say a parent of 11 children, well, now those damages are far more extraordinary than killing a parent of 2 children, right? And so I suppose there's an argument that the current law in its current format sort of constrains those damages to the economic value of one's life. I don't agree with that, but I can understand that, I guess to some extent, the logic, but it's outdated. I think we are one of 2 or one of 4 states in the union that still utilize this outdated law.
Yeah, I think there's only a couple states in the whole country that have laws like this.
Right.
Even in some like southern states that are, I'll say not so lawsuit friendly, they have a better wrongful death law than New York State.
Yeah, it's really wild. It's wild, especially because New York, we pretend to be a progressive state. We tend to we tell ourselves that we're on the forefront of these legal and salient issues of our time. Here, we're operating in the Stone Age. It's ridiculous. Yeah. And you and I both know that New York State's trial lawyers and many other union groups and community groups, religious organizations had gathered together and are still working together. I think this started 5+ years ago in an effort to amend our law, to change it, to bring it current so that grieving families of deceased people could recover for their emotional suffering. It passed the New York State's legislature, both houses of our legislature.
By far. And both parties agreed.
Both parties agreed. 2 years running, at least. It went in front of the governor both years, and she did not sign it. She went with corporate America. She was influenced by the lobbying of big insurance, health insurance, life insurance companies, liability insurance companies, trucking industry, healthcare industry, right? Because doctors, they're worried about it, right? They're worried about hospitals. They're worried about it. If they kill someone due to their negligent acts, they don't want to be held accountable by paying these families the value of their emotional suffering. And so the governor failed the people of New York.
Yeah, I think that the first time it went before the governor, she just let the bill die. She has to sign it within a certain time frame, and if she doesn't, then it just dies. Then the second time, it was December of 2023 when it was presented to her, and I don't recall if she vetoed it or sent it back somehow, but there was a memo that I read a little while after it came out, and and the governor said that she was concerned about more or less about insurance companies, about insurance premiums, and that she thought the bill was too expansive and that it would open claims for too many people. So for example, like if one person dies, I mean, you could theoretically say that their whole family, I suppose, could make a claim, but that's not the intent of the law. It's not, if one person dies, you're not going to get hit with, there's not 20 lawsuits out there.
Well, I think one of her concerns was that like mom and dad of the child could file a claim and then aunts and uncles could do it too. And I think she wanted it confined to immediate family. And listen, I understand. I think there should be some, there's some reasonable.
But it sounded like it was confined to some extent.
I don't know the version that she didn't like, but yeah, I think we are really dismayed at this point because this governor has run on a platform of being a progressive, and this isn't even progressive. At this point, we are the minority by far, and this statute needs to be changed. There are grieving families out there. I mean, think about the families of blue-collar workers, iron workers, people in the construction trade who are building these skyscrapers on behalf of some of the richest landowners and corporations in America. These men and women put their lives in harm's way every day, making a wage. Their families depend on them, and they fall off a scaffold or they're crushed by something at a construction site, and their families are limited to the money that the parent would have earned, but they get no recovery whatsoever for the emotional toll that it would obviously take on a family if a father dies and has young children at home, or if a mother dies and there are young children at home. So I just think it's a really unfair body of law.
Yeah.
Now one thing we didn't discuss so far is oftentimes, not always, but often when we file wrongful death claims on behalf of our injured clients, we file another claim with that wrongful death claim. So we also file a claim for pre-death conscious pain and suffering, right? So there are two claims. So let's say there's a car accident and our client passes as a result of that crash. We file a claim for pre-death conscious pain and suffering, and we file simultaneously a claim for wrongful death. The action for pre-death conscious pain and suffering belongs to the deceased person. It passes by laws of intestacy or through their will if it has, because it's an asset of the estate. And so I think that's just an interesting thing. And then wrongful death does not belong to the deceased person. Wrongful death belongs to that person's distributees. And oftentimes we might get extraordinary recoveries on these wrongful death claims if we can prove that there was some pre-death conscious pain and suffering, because now there's no confinement to the economic claim. But if you can't prove pre-death conscious pain and suffering, which is often difficult to do when you're dealing with a horrible accident, oftentimes these people die instantaneously, then you are confined to that wrongful death claim, and that's where you need economic value. What's really horrible is this. Think about a mother who decides as a family, as a unit, that she's going to stay home and raise her children. And then she is going to the grocery store and there's a horrible crash and she dies and she has young children at home. Under our law, that woman has little economic value. Now, we can hire an economist to evaluate her economic value to the family, but it's a difficult claim as compared to the other spouse who might be out working for a W-2 wage. You can plug in the math and there's the W-2. That's how much money that person earned. That's why it's unfair, because people who do contribute to this world and to their families may not have easily measurable economic value, and that's one of the reasons why it needs to change.
And to bring a wrongful death case, it can only be brought by the person's estate. So some random family members can't just go and file a lawsuit on behalf of someone who was killed. So one family member typically, you can have more than one administrator or executor of an estate, but ordinarily it's one person who applies to the surrogate court on behalf of the distributees, and then the surrogate court, has to approve it or not. Sometimes more than one person applies for it, so the surrogate court decides who to appoint, and then the person who's appointed can then go ahead and bring a wrongful death lawsuit. Now, going back to the Grieving Families Act, in order for someone to have the term is standing, which means to be the right person to bring a wrongful death claim, they're typically a distributee of the estate, and there's an order. If a person passes away without a will, there's an order as to how people inherit. It goes to the spouse, children, parents, and so on. And so I don't think there's going to be, if that law eventually does pass, I don't think that there's going to be people coming out of the woodwork, all throughout a person's extended family to bring a claim, because they won't have standing to bring any sort of a claim under the estate laws of New York State. So it would only be the immediate family, a spouse, children. That's about it. If a person didn't have a spouse or children, then it would be, their parents. And then if a person does not have parents, then we go to their siblings. So it would just be the next of kin, whoever's next in line, that would be entitled to to bring a wrongful death claim.
Oh, I think what's also interesting is that the liability insurance companies know that New York State is not a plaintiff-friendly state as it relates to wrongful death, and they know it, and they use it against us so that they can further line their pockets with money that should be going to these grieving families, that should be going to benefit the family of someone who was taken from the world too early. And that the law doesn't really take into account that these insurance companies literally will laugh at us. These insurance adjusters, they're so demeaning when they talk to you and they're like, "Oh yeah, really sorry about the loss of life there, but you can't prove any economic value to that retired individual who was riding his motorcycle at 76 years old, so we're not going to pay you." I mean, does that sound even remotely just? I remember I had a case with a gentleman. He was retired. He was enjoying his retirement years. He was riding his motorcycle down in Long Island. Now, at this point, because he's retired, he has no economic value to his family, right? I mean, he's living off his pension, and the family's going to receive that pension benefit anyway as a beneficiary of that fund. So he has zero economic value to the world. He's riding his motorcycle, and a woman runs a red light, kills him instantaneously. I'll tell you about that in a second. But so we really don't have a great pre-death conscious pain and suffering claim, and the insurance company says, we're not going to pay you. Our insured ran a red light, kills the motorcycle driver. We're not going to pay you. Why? Because he doesn't have a job and his children don't depend on him, so he has no economic value. Says it with a straight face. Now, thankfully, in that case, the police officer who responded to the scene knew about this unjust law, and he said that he heard the gentleman moaning at the scene as if he was in pain, and that was enough to change the insurance company's mind to pay. But you don't always get that witness. You don't always get the police officer who is smart enough to help a grieving family by making a statement like that. And I'll never forget that insurance adjuster. I could hear the smile on his face when he was telling me, we're not going to pay you because that man had no economic value. So I just thought I would share that. We should also just say one other thing about wrongful death. What's the statute of limitations?
It's 2 years, so they've shortened it. So it's 3 years ordinarily for an injury,
right, and
2 years for wrongful death.
Right. So now these families, they're grieving. They're not going to get paid for any non-economic harm that they suffer, such as the emotional suffering that they experience. But they also have to get going. They have to be really fast in order to get their damages, because the statute of limitations for wrongful death is much shorter than your general negligence cases. It's 1 whole year shorter. So you have 2 years, and you have to get that process moving, because, as you said earlier, the family members have to designate someone to serve as the administrator of the estate. An estate has to be opened, and while that process can be relatively efficient for most families, it's not always a fast process.
No, it can take a while to get through surrogate court, and every county is different. Some are faster than others, but the process of the back and forth can take a while. And then occasionally a family member will challenge the appointment.
Right.
And you can get bogged down even longer.
Yep. All right. Well, I think that's all we have for today's case in chief. Is it legal? That's the next segment of our show. Derek, are there alternative dispute resolution methods, such as mediation or arbitration, that can be effective in resolving a wrongful death case?
Yes. I'll say if both sides are open to it, to me, in terms of deciding whether to go to arbitration or mediation, it's not worth it if the insurance company is not going to offer you anything realistic. So, if you go to a mediation, and let me just explain the difference. If you go to a mediation, that's when you sit down with usually a retired judge or another attorney, and then they try to settle the case with you. If you go to arbitration, then a retired judge or attorney actually decides the case. So going to mediation, that's not. I'll say I've had good results at mediations over the years, but only when the insurance company is really willing to come to the table and negotiate. And so, it's definitely worth it if they're willing to go to a mediation and try to resolve it. And then with arbitration, I guess I've never done an arbitration on a wrongful death case before, but I'd be open to it in the right circumstances. And I feel like an arbitrator would understand the law, basically the same as a judge, so it's the same as a bench trial in theory. Arbitrations are useful in cutting out trial costs. So if you go to a trial, you have to almost always bring a doctor live, at least one doctor, if not more than one doctor. Sometimes liability experts. You can spend $20,000, $30,000, $40,000 on trials based on how complex they are. If you go to an arbitration, you don't need to bring those witnesses. You can, but you're also allowed to rely on their reports. So if you have good reports from your experts, you can just submit those to the arbitrator, whereas at trial, you can't submit your expert reports to the judge or jury. They're not considered evidence. So the rules of evidence change at arbitrations, which I'll say open the door more for both sides to submit their proof. So, to answer the question, yes, I'd be willing to do that in the right circumstances.
Okay.
So, John, can you explain the concept of negligence and its role in wrongful death cases?
Man, we're getting pedagogical here.
Yeah.
Okay. Well, negligence is the lack of ordinary care. So it's really a reasonable person standard. When you and I take these cases, we are generally thinking about trial and what would we say to a jury in trial. And we're trying to prove that the negligent party lacked ordinary care. They did something that a reasonably prudent person would not do, or they failed to do something that a reasonably prudent person would do when confronted by those same circumstances. And when you say it like that, I think it does help orient the jury. Negligence is not an intentional act. It's not reckless. It's just that failure to use reasonable care. And if you think about it, that's the lack of ordinary care causes most injuries, right? We trip and fall over something, and sure, I guess we could have been more careful, but maybe the landlord also thought, well, it's not that bad, right? But that's a lack of ordinary care when you fail to level off that sidewalk, or when you take your eyes off the road to look at your cell phone. You're not being reasonably safe, right? You're being negligent, and it's not. The allegations are not to besmirch anyone. It's not to suggest that that person is evil. They made a mistake in the moment. They neglected their duty of care. Right, when you're driving on a road, you have a duty to be reasonably safe so that you don't hurt people and cause accidents. And when you fail to comply with the rules of the road or just things that reasonably prudent people would do or not do, then you're dangerous in that instance. And so that's what negligence is. It's a lack of ordinary care.
And staying on that topic for a moment, I read that the first case that you talked about, the product liability trial with the post-trial motion. Well, when I read through that transcript, the jury asked to have the negligence charge read back to them. So at the end of the trial, there's these pattern jury instructions, and one of them contains the definition of negligence. It's a fairly lengthy definition, but it seems that after almost every trial, I'll say, but maybe it's 3/4 of the trials that I've done in my lifetime, the jury, after all those instructions, the jury goes into the room to deliberate, and then they come back out at some point with a note, and they want the definition of negligence read back to them.
You're right.
That happens time and time again, and it's really the pattern jury instructions. We could even do a podcast on how poorly written they are. But the negligence charge, it's hard to make sense of it, even as an attorney. Like the lack of ordinary care. Sure, like I get the concept, and there's more to it in the definition. But after the whole trial, the jury's then given this somewhat convoluted definition of negligence to go ahead and figure out, was the defendant negligent? And it's almost like you may as well just toss a coin sometimes.
It's funny because the pattern jury instruction that defines negligence, I think, is really only like 5 sentences. However, let's say you've never done that thing before. So let's say you have a case against somebody operating a chainsaw, but you've never operated a chainsaw. So how do you know what the ordinary person does when operating a chainsaw if you've never operated a chainsaw? And so then the statutory body or the pattern jury instructions attempt to give you some ability to quantify the negligence, right? So then we get into the issue of foreseeability. You're not reasonable under the circumstances if the harm that you might cause was reasonably foreseeable. And then it goes into notice and all of these other things. And that's where I think the law gets really convoluted. But I agree with you. I think serving as a juror for a week or 2 or 3, whatever it may be, listening to this whole trial, and then at the end, listening to this judge read 45 minutes worth of law to you is an absolutely insane concept.
Yeah.
I tell the jury in my closing arguments now, I invite them. I say, listen, you're the most powerful people here. You can see the evidence again. If you want it, you can ask for it. If you want to hear the transcript of Dr. So-and-so's testimony, you can hear it twice. If you want to hear the law again, tell the judge, I didn't understand that. I want to hear it again. Ask to see it in writing. I tell them, you are the bosses. You tell us what you need to make your decision. And I think you're right. They ask for the law.
Yeah. And in some cases it's more clear cut, but if you have a case that's, let's say, factually difficult or just not an ordinary case, then what is ordinary care? If you have an abnormal situation, what's ordinary care? Yeah. And it's so, it makes just makes things arbitrary, which is not the purpose of the law. It's supposed to be, I'll say more black and white. There's some, always some wiggle room, but.
Well, you might be calling into question the utility of jury trials.
Yeah. I mean, and I know that you could present the same exact fact pattern
to 10 different
juries, and you get 10 different verdicts all over the place.
You're right. You're right.
It's arbitrary. Yeah. I mean, there's all sorts of factors that go into it, and of course, if you have a good lawyer versus a not so good lawyer, you're a lot more likely to get a good result. But
I think the idea of the jury trial is just to have an outlet, is somewhere to go. You have somewhere to go to resolve your dispute. We all know it's crazy, which is why these cases settle, right? Yeah. We all know it's nuts. And you can't forecast the outcome. So if you two can't figure out your fight, this is how you go do it, in the crazy room with all the crazy people. No, just kidding. All right.
Let's get local. What are some hidden gems or favorite local spots in Kingston that you would recommend to someone visiting our town for the first time? Snapper McGee's.
I knew he was going to say it. I knew it. I knew Derek's was Snappers.
I don't know. We have a bunch of good restaurants, cool bars. Keegan L's is always a fun time.
Sunrise Bagel. I would tell somebody to go to Sunrise Bagel, get the bacon, egg, and cheese with a chocolate milk, and enjoy your day. But Sunrise Bagels has been around since I was in high school.
Oh yeah, it's gotta be.
That was unfortunately far too long ago. That was 20 years ago. So I think Sunrise Bagels would be my hidden gem of Kingston, New York.
They do have some excellent bagels.
Do you go?
Big. Not often, but like on like when I'm out that way and have a little time, I'll stop in there. But they're always substantial. Like you better be hungry.
Well, so I had a visitor at the office recently, and he said to me, "Hey, what do you know about Sunrise Bagels?" And I, of course, I could write a whole monologue about that, but I said, "Well, it's been here forever. They're really good bagels. They're big bagels, but they're very good." And I said, "I think you should get like a sandwich of some sort." And he was visiting town, and he had looked it up, and it got really good reviews, and it was out of his way, but he wanted to call in an order. And I said, "Dude, it's like 10 minutes out of your way. Just go do it."
And one more thing, I'll throw in one more. Egg rolls from Ing's on Broadway. Okay. There's a lawyer in Albany who, we're doing things virtually now, but he refuses to do anything virtually on this case that I have. He wants to come down for every conference in person. He asked the judge for in-person conferences instead of virtual. He asked him for around noontime, like late morning. And we did a couple of depositions. He did those in person at the office. And so after he came down a couple of times, I was like, "Why do you want to always do this in person?" He's like, "Ing's."
Oh,
and so he stops at Ing's every time he comes down.
It's always food that's the motivator.
Yeah.
See, like, for example, I like to go to Albany for cases, litigation proceedings, because I like to go shopping. I like to go to Whole Foods or Trader Joe's, and we just don't have those here. So food is still, I guess, the motivator there. But yeah, that's what I like to do when I get sent out into the world. I like to try to disappear for a few hours and do some shopping or something like that. When I was a younger lawyer, I always used to race back to the office because I thought I was going to get in trouble or something. Now I'm like, peace. All right. Well, we got local for a minute. Now we have closing arguments.
All right. Thanks for listening. We hope you found our podcast interesting and enjoyable.
If you enjoyed the content, please consider subscribing to our podcast. Give us a like, and we'll see you next time.